I welcome the court's questions.
What do you do with Mr. Liu's argument that the waiver of immunity did not include bad things that happened to the mail? He said that generally, and that Dolan, because it wasn't about bad things happening to the mail, was outside the waiver of immunity.
So I think that's just
was included in the waiver.
I understand. Yeah. Thank you, Justice Thomas. So I think that's just an overreading of Dolan. So the sentence says that he points to says something like, as a general rule, these sorts of damages don't lie. It's using that hedging language because, again, as a general rule, we're talking about good faith mistakes. We're not talking about the rare instance where a postal worker is using the mail to effectuate harassment on somebody. So I think even taking that sentence of Dolan at face value, right, wrongful conduct was not before the court in Dolan, but even assuming it was covering that, I think that's what the phrase the general rule is doing. And I suppose I would say that feels passing strange given the rest of the statute. And its emphasis on kind of specifically carving out property-related torts. So for instance, 2680H, the so-called intentional tort exception, conspicuously omits conversion and trespass, the two property torts. And so I think what my friend on the other side is saying is no one in the federal government can engage in conversion and be exempt from, and have the United States be exempt from liability, except for postal workers.
Is there a long history of Federal Tort Claims Act suits about the mail itself, delivery, non-delivery laws?
So there are some cases. We'll note that, kind of in response to Justice Jackson's question, most of those don't even get into court under 1346B. If you just say, my package doesn't show up, it gets kicked out of court because you don't even plausibly allege negligence, let alone wrongful conduct, right?
But you would think that with 300 million pieces of mail per day, you would have a significant number of suits that do involve this level of harm.
So I think you may have some number of suits that involve this level of harm, meaning enough to prompt someone to go to court and sue, but not that involve wrongful conduct within the scope of employment, right? That's a very narrow needle to thread. Think about what Ms. Konan alleged here, right? 2 years of non-delivery, not just a one-off package. She's filed administrative complaint after administrative complaint. She can say, look, every single one of my neighbors is getting mail. She says, when you found out I own this other property, mail stopped getting delivered there. She's got all this other kind of circumstantial evidence that doesn't have to do with the mail delivery. Those sorts of allegations, I think, will be rare. And remember, the government came before you in Dolan and said, if you rule for petitioner, frivolous claims will inundate the Postal Service. A decade later, they're coming and saying, actually, the postal exception is working just as it should. And so I'd be a little bit hesitant to believe those claims.